around this whole area. He does not lament.
We would call under mediation or area, the snowball, Ntinda, Industrial Court, Justice Ida from the Land Division, actually Family Division, and Syria and Kate. She's the one who brings
really leading in this, because then it is going to have a ripple effect on the other divisions. It is already having it. We have commercial doing well. We have land division now starting, and for criminal division we already have pre-bargain, and we know the problems with the Justice Abodo, that yours cannot work because of the kind of the clients that you have there. We understand that, but the few that fall through in pre-bargain, we celebrate those, because you know these disputes don't only affect the parties. In the long run, it affects even us judicial officers. We get drained, we get so sucked in this. So if we do mediation, we are actually, you're just working on our wellness, we're working on the wellness of the, and then the ripple effects that it has, more harmony in the community. And that's why we are saying we go mediation. So we are really on the right track. Also the kind of mediators you get also speaks to the success of the mediation. You don't get mediators who are not patient, who are not professional, who don't have integrity. Then you can't really have preach alternative dispute resolution, because we have so many cases, but we can never have enough judges, enough registrars, enough magistrates to handle the cases, because we are a big population. We are almost 50 million. How many judges can you have? You can't have so many. So we know that case management is also about choosing what cases actually go to court. Let's have cases in court which are really deserve to be in court, but the majority of the cases really can be handled through alternative dispute.
This settlement fortnight is mainly for administration causes. As you remember, in 2022, Parliament amended the Succession Act and put a cap on the duration of administration, letters of administration or letters of probate. So it meant that all the letters of administration which were previously granted by courts expired on the same day, and that is the ones that came on 31st May 2025. So we had over 10,000 applications for extensions of grants. And the importance of these grants is very clear. If the letters of administration expire, it means that you cannot go to the bank to withdraw money to pay school fees for your children. You cannot go to the bank to get money to pay for medical attention. You cannot defend your estate, your property that your deceased or relative left. That is how critical these letters of administration are. So because of that expiry, we got an avalanche of applications. And these avalanches come with problems. You know, when you are trying to extend grants, some people come and say you have, for example, mismanaged the estate. We don't want you to manage the estate further. Yet the law says before you extend, the family must give consent. So to generate that consensus, we've had to send many matters to mediators to help the families agree. They can agree either to maintain the administrators who are currently administering, or they can choose other family members they believe they can do a better job. So that has caused, in many matters, actually 70% pending mediation causes are in relation to extensions of grants, where administrators have mismanaged and the families are disagreeing on who should continue the administration.
Joined Deputy Kisa, the other bishops are also